It is showtime. We are live back with another weekly show where we have a lot to talk about. I am your host, for those of you who don't know, Dave, 10-year intellectual property attorney, dealing with everything from trademarks, copyrights, patents, trade secrets. We have a little bit of everything to discuss. Seems like we'll do the interview that dropped this week on Snow Scholar. Seems like Beyonce and Chloe Bailey was sued for copyright infringement, so we kind of take a little bit of a look at that. It seems like Beyonce was pretty furious of the lawsuit. We also take a look at Warner Brothers. Those of you who know the famous yet old show, A Christmas Story, it seems like a small town has created a 40-foot leg lamp from the Christmas Story, and it seems like Warner Brothers, who owns the IP to the Christmas Story, is suing that small town for, again, copyright infringement. I just saw this yesterday, and I did a video earlier, but the CEO of Actively Black, I think Lanny Smith, he seems to be fed up with the black delegation here. He goes on a rant on IG. We'll take a look at that and see what, some learning lessons from that as well. And then we'll get off into Jalen Hurts. Jalen Hurts, for those of you who don't know, the quarterback of the Super Bowl winning Philadelphia Eagles. He had this Love Hurt shirt on at the Super Bowl parade back in February. And it'd be interesting how somebody they saw that and they try to take advantage of it. So we will kind of talk about that. And then last but not least, we're going to do the lawsuit of the week. Michael Kors has sued another company for trademark infringement of his famous MK symbol, as well as this kind of trade dress on his design bag. So we got a lot to get off into. We're going to start with Snow Scholar here. I'm going to kind of bring up that. As I'm bringing up the video, please hit the like button for the YouTube algorithm, as well as hit the subscribe button to be a part of the IP community. I would love to have you guys as part of the IP community, where we talk about a lot of different things on this channel here. So let me bring this up. Snow Scholar. So, man, this guy, and I love to interview, especially these young guys, because they crush it. So Jake Pozarski, the interview dropped this past week. I interviewed him maybe a month or so ago, but he just recently graduated from Wisconsin. Shout out to my Michigan State Spartans for beating Wisconsin in basketball today. But he recently graduated from the University of Wisconsin, and he came out with essentially what I call the Uber of snow removal. He has an app that he created for like college students on college campuses to be able to kind of earn money, $25, $30 an hour. He's going to talk about it here. But the app pretty much facilitates users, again, college students, to be able to kind of shovel snow for people within the community that wants their snow shoveled, particularly elderly, older people who are kind of want to get back to the community, want to get back to college students, help them out financially. This is a way to do it. He created this app, and I'm going to have him talk about it a little bit. Again, please go take a look at the full interview. I'm not going to play the full interview here. I'm going to just give you a minute or so clip, and then I'll kind of give you my thoughts on it. Let's go.
Started in 2022. Now we're operating at 6 campuses. We are a residential snow removal company that employs college students. We welcome anyone to apply, but college students is our main focus. It's our mission. I just graduated college myself, and giving college students the opportunity to earn $25 to $35 an hour and help out homeowners it's what we do.
No, and again, that's man, I know we're talking about Michigan State and East Lansing and getting some snow. Man, back when I was on college, maybe 10 years or so ago, it was and I worked at like the physical plant, which is like maintenance facilities, and I can tell you what, I wasn't getting paid $30 an hour. I think it was like $10 or $15 an hour. So I love what you guys are doing, because it seems like in addition to being able to pay a decent amount, you guys, it also provides flexibility for the students so that they don't have to be here for 8 hours or there for 20 hours or whatever the case, or 20 hours a week or whatever the case may be. They can kind of do this thing at their own pace. Is that accurate?
That's right, man. We have kids that work 5 hours a week. We have other kids that work 150 hours a month. So, depending on their location, their availability, and how dedicated they are to their schooling at that time. But yeah, it's very flexible, and our homeowners know too, the biggest reason why they employ us is to support students. So kids start early in the morning, go to class, and then finish the less urgent homes in the afternoon.
Again, man, that's what I call the Uber of snow removal. Please go check out that full video on the channel, man. Jake He's killing the game. Like I said, they employ students getting paid $25 to $30 an hour. He's from Wisconsin, so obviously they're doing the University of Wisconsin in Madison. Hey, they're on Michigan State's campus, which is my alma mater. They're on a lot of other schools here in Michigan, the great state of Michigan. I think Grand Valley. I think they said they were kind of rolling out Eastern and U of M in Ann Arbor and a few other schools here in Michigan. I think they're in Minnesota, various schools out on the East Coast. So, hey, Jake, again, this guy's 22, 23 years old. He's a serial entrepreneur. This is his latest thing. And he did get a deal with Mark Cuban, which we talk about later on in the interview. He was on Shark Tank. He got a deal with Mark Cuban. Pretty much gave him like, man, I forget what it was, maybe $300,000 for like 20% or something. Great deal. He said Mark Cuban is amazing. So please go check out that interview as we move on to the next show here. Your girl Beyonce. Now, I will pull up the article. I'm not going to read it, but just kind of this is like a quick hits part of the show where we are kind of doing some quick hits. And it seems like Beyonce, I didn't realize that she had an actual a record label. Parkway, I think Entertainment is the name of the record label. And one of our artists is Chloe Bailey. And it seems like Chloe Bailey, who just recently came out with an album, it appears that she had using someone else who claimed she took his IP copyright specifically and used it without his permission. So again, it seems like Chloe Bailey as well as Beyonce was wrapped up in this lawsuit. And from kind of me going through the lawsuit, Beyonce was pretty pissed off and furious. The article said, this particular article said about actually being in this lawsuit. She thinks it's a bad look for the company. She thinks it's a bad look for her. Then if you guys remember Blurred Lines, which is a famous song back in the day, Robin Thicke, Pharrell, that kind of took some elements out of a Marvin Gaye song. And they talk about all this in an article, but it took some elements of the Marvin Gaye song. And Marvin Gaye's estate actually sued Pharrell and Robin Thicke for Blurred Lines. And the jury ended up awarding them $5+ million. And they have a royalty that's 50% of the song, everything that the song makes going forward. And it seems like Beyonce, with this particular situation, she did not want to get wrapped up into this lawsuit. In part because of how that Robin Thicke Pharrell's situation played out, it seems like, and that was a part of her frustration with this lawsuit. And then again, I mean, obviously she has a company, Parkwood Entertainment, but this is not something that she did specifically. It seems like her company is wrapped into the lawsuit. So again, it's part of owning a business. Like I said, this IP stuff is valuable going back from Jake, and what we didn't talk about, or what the clip that I didn't play in that Jake interview with Snow Scholar is, he has IP on in terms of the trademarks on the name. He has trade secrets on the code. So he has a lot of different IP in it. And again, obviously with this Beyonce lawsuit, copyright infringement, again, seems like something may be going on. So I'm gonna try to kind of keep up with that lawsuit. But this is the quick hits part of the show where we're just kind of going through some stuff before we get to the main lawsuit here, which is Michael Kors today. So that's that. The next one, this is my favorite. I'm not sure if you guys know about The Christmas Story. Let me know in the chat, for those of you who are here, if you know about the famous movie The Christmas Story, which literally on Christmas Day, seems like on Christmas Day, the Christmas Story, it plays nonstop for the whole 24 hours of Christmas Day. And it seems like, as you can see here, let me pull it up really quickly. This leg lamp is famous from A Christmas Story, and obviously A Christmas Story is owned by Warner Brothers, own the copyright for the movie. And it seems like this small town, you see Chickasha. Anytime a town is named Chickasha, you know it's a small town. And it seems like Warner Brothers is kind of fed up with this small town for potentially committing copyright infringement. So let's play the news article here, and then again, I would love to hear you guys' thoughts in the comment section, or in the chat. I should say in the chat. So let's go and see what I think this is a newscasting, a broadcast out of Chickasha, Oklahoma. So small town in Oklahoma. Let's go. Is it going to play or no? Let's see here, man. What is going on? This was a fun article, man. There we go. There we go. Is it going to play?
The Chickasha Community Foundation says Warner Brothers has reached out to them demanding the removal and destruction of the town.
Sounds like a cease and desist to
Say
me.
the entertainment company claims the structure is a copyright infringement. Fox 25's David Chesnoff spoke with the foundation. David, how are they reacting?
Adam Wendy, Jim Cowan with the foundation tells me there's been lots of conversations about this, so there haven't been any lawsuits about this 40-foot tall replica structure.
Look at, man, isn't that not crazy? A 40-foot tall replica structure of that leg lamp in A Christmas Story. That's crazy.
The leg lamp has worked, okay? We're not trying to infringe upon anything.
Documents from October that Fox 25 obtained shows Warner Brothers telling many Chickasha groups that it owns the copyright and trademark for the leg lamp from the movie A Christmas Story. The entertainment company then demanded the removal and destruction of the Chickasha Community Foundation's replica structure.
The ones that hate this thing, they didn't want to understand. They were just like, oh, I told you we're going to get sued, told you we're going to get sued. And the reality is,
should have took that advice.
No lawsuit. But the biggest thing is, this isn't an amusement park. It didn't cost you $20 to come in and see the world's largest leg lamp. The only thing we're selling is officially.
Hey, how much do you guys think in the chat that leg lamp cost that town of in Oklahoma? That seems like that's a $50,000 leg lamp, 40-foot tall. Which again, you should get advice on whether or not you're infringing something before you actually spend that much money on a 40-foot replica of a leg lamp that is owned by Warner Brothers.
Licensed merchandise. So there is no infringement.
Cowan says when the foundation first wanted to bring a leg lamp to town, the community foundation asked Warner Brothers if they wanted to help pay for it. Records show Warner Brothers responded in 2019, saying in part that they decided not to grant the permission that was requested.
It's a piece of art.
So Warner Brothers, look it, and that's still crazy, a crazy big leg lamp. But Warner Brothers, when they asked permission years ago, said no, we don't give you permission, and it seems like they did it anyway. Now it seems like Warner Brothers is allowing them to sell some kind of small leg lamps, and they got permission for that. But this big leg lamp here, which again is a 3D sculpture, which is protectable via copyright. Warner Brothers didn't give them permission for it. They did it anyway, and now they find themselves potentially looking at a lawsuit here. Let's finish out this.
Art that is not owned by the city. It's owned by the Chickasha Community Foundation, and the land that it's on is owned by University of Science and Arts of Oklahoma.
Mayor Zachary Grayson says while the city isn't involved in this situation, he hopes it doesn't result in litigation.
I don't want.
Hey, if your mirror looks like this, that's a small town. If this is the outlook of the profile of your mirror in your town is probably, it's considered a small town.
To go into a lawsuit because obviously the only people that win in a lawsuit is lawyers. And so I hope there's a way forward with Warner Brothers and the Community Foundation to work it out.
An anonymous Chickasha resident who helped Fox 25 obtain those documents tell us in part, we are simply fighting for truth, integrity, financial transparency, accountability, and honesty regarding our taxpayer dollars and decisions for our community. And you can read the rest of their statement on our website right now. That's okcfox.com. Reporting live in Chickasha, David Chasanoff, Fox 25 News.
So there you go. There you go, folks. Seems like Warner Brothers is in Chickasha. Again, anytime your town name is Chickasha, you're definitely a small town. But you guys have to let me know what you guys think about that in the comment section. Again, let this be a lesson. If you're going to spend a substantial amount of money on something that kind of maybe is committing some type of IP infringement, whether it's trademarks, in this case it was copyright, whether it's patents, trade secrets, whatever the case may be, you probably want to kind of call a lawyer on that, especially if the company told you when you gave asked for permission a couple of years prior that they didn't give you permission for you to do it anyway. It seems like you kind of get what you have coming for you at that point. So let's move on here, continue the show, continue the program. Actively Black. Seems like Actively Black. Let me take off my headphones here. Seems like Actively Black, and we're going to pull up the IG post from your boy. I think Lenny is his name. Lanny Smith. Seems like Lanny Smith and Sheen, and we all know how I feel about Sheen, whether Sheen or Temu. Seems like Sheen was selling knockoffs, Actively Black gear on their website, and seems like Lanny Smith and the team over there, Actively Black, didn't take too kind of it. They sent Sheen a cease and desist letter. I'm going to show you that cease and desist letter here in a second. But on his IG post, where Lanny Smith, the CEO, the founder of Actively Black, posted the actual cease and desist letter, he seems to kind of go off on the black community for kind of always complaining and always hating. Now, I'm a big proponent of, if you're starting a business, I'm not necessarily a big proponent of kind of saying, hey, this business is for black people. I like for you, again, if this, hey, man, you know, David, he own such and such company. And, oh, by the way, man, he a black individual. He a cool dude. I like for that to be the narrative. I don't like for it to be put out there as, hey, he has this black-owned company or this company that's kind of really directed towards black people, because I think you ostracize everyone else when you do that. But, again, it seems like Actively Black, they have done that, and it seems like they've been successful to the tune of making millions of dollars in revenue over the last few years, kind of selling a product. However, man, look, when you're dealing with black people, you got to expect that they're going to talk some stuff. So with all that being said, let's kind of get off into his actual IG post. So let's go through it here really quickly. So this is the cease and desist letter that Lanny Smith, which you see L Smith 23, he posted on his IG page, and he posted this yesterday. So this is really fresh off the press. And this, you see here the subject: Sheen U.S. Services LLC's unauthorized use of Actively Black Inc.'s trademark. So obviously this is a trademark matter, and he has most of the letter blotted out. But let's kind of read the portion that's not blotted out. Our firms represent Actively Black Inc., an innovative company offering premium quality athleisure wear and apparel that, and then that's where it starts to get blotted out at. But if you look at here to the right, again, he's going off on the black delegation here. This would be my last time addressing this. Our attorneys have sent a cease and desist letter to Sheen official for blatant ripping off the Actively Black brand. But I'm not even mad at the bootleggers. I can't control that. So he said, look, I'm not even really pissed off at Sheen. It's business as usual. We're going to have our team send a cease and desist letter, get this stuff taken down, and go from there. But who is he mad at? I'm mad that my own people are choosing to go shop at Sheen and others to buy fake Actively Black gear instead of actually buying it from the black-owned brand that created the gear. Like I said, I'm not a big proponent of saying, hey, a black-owned brand, just let it be a brand, and if black people rock with it, if Asians rock with it, if Hispanic rocks with it, if white people rock with it, let that just be the case. But again, they kind of are different in that regard, which again, it is what it is. Let's continue reading here really quickly. I see all the comments about Actively Black being too expensive and costing too much. What comments are you talking about, Lanny? Well, let's see here. He posted them. He got the receipts for y'all. So your boy Way Too Chill commented, I like the clothes and support the concept, but $100 for a hoodie? Hell no. Most black people willing to support the culture, but not at that cost. Black businesses that truly support the community aren't trying to take advantage of willingness. That's your boy Way Too Chill. Will the Barber says they diddled the price. So being Actively Black looks expensive. I'll stay inactive. See what he did there. Inactive, active. I see what you did there, Will the Barber. Let's see another one. We always trying to overcharge our own people. A fucking t-shirt from what I'm considering is a startup company at $50. Y'all crazy. I want support, but good luck. So these are all people pretty much saying they just complaining about the price as he talked about it. And I actually like the product. I think the product is super dope. You see it here, a hoodie and some jogging pants. You see a video here. I actually like that sleeveless hoodie. I mean, again, the product is dope. Now I think that's Lanny right there. But as I bring it back on myself, the reason that, again, and first of all, shout out to Actively Black for kind of taking care of business on the business front. Sheen, which we all know Sheen seems like they're known for selling other people or kind of copying other people product and selling them for the low. Seems like Actively Black is the latest company that they did that too. But again, business as usual. They sent the cease and desist letter. I'm sure that Sheen would have it taken down, and then it'll be kind of off from there. But I really kind of brought up this article, number one, because of kind of dealing with trademarks. But number two, yeah, man, and people may disagree with me. Let me know if you disagree with me in the comment section. I'm more cool with you being a CEO and you being black and you having a brand. I don't necessarily like to say, hey, I got a black-owned brand or a black-owned company, because we all know black people talk about supporting black people, but it seems like it's a limit to how much they're willing to support you. If it costs $50 for a t-shirt, they're probably not willing to support you. You guys got to check out my full video I made of this, because it's a company that I actually broke down that lawsuit months ago called Aviator Nation. It's a company out of California, a small company. She's built a business because the woman is the founder is a woman. She's built a business worth hundreds of millions of dollars. She makes millions of dollars every year. And if you go look, I'm not going to pull it up for time purposes, but her t-shirts are $100. Her hoodies are almost $200. So they're really double the price of your boy Lanny Smith at Actively Black. And she developed her community, and people rock with her based on rocking with her community, being a part of the community, and nobody's complaining. So when you kind of market yourself to Black people, it seems like Black people want to kind of support you at a limit. If stuff starts to get too much, then they kind of want to complain and don't want to support you. And it seems like Lanny Smith is fed up with it, kind of giving this Instagram post. And that's why I say, hey, man, just put out your product, put out dope product. And whether somebody's blue, green, Black, white, Hispanic, Asian, if they're going to rock with you, they're going to rock with you. They're not going to rock with you because you cheap or because kind of you Black or whatever the case may be. They're going to rock with you because the product is dope. They're willing to pay higher prices for a dope product and for kind of what the brand stands for. So kind of that's my 2 cents on that. Let me know in the comment section if you guys disagree with me. But we're going to move on to the next one. Your boy Jalen Hurts. And I actually got a news article out of Philadelphia on this one. So we're going to play that, and then I'm going to kind of give you guys my 2 cents on it. So let me put in the headphones as I pull this up here. Hopefully this one works better than the last one, but let's go.
During the Eagles' victory parade could become trademarked. Jalen Hurts wore a hoodie you'll remember with the phrase "Love Hurts" above the Jumpman logo, which is a Nike brand. A woman in Fair Lawn, New Jersey, filed a trademark for the phrase before the parade even ended. Meanwhile, Eagles general manager Howie Roseman is looking to trademark the phrase "I bleed for this city." He shouted those words at the art museum steps after getting hit in the head with a beer can during the parade. Any proceeds from using that phrase would reportedly be donated to charity.
And he's talking about being creative, getting hit with a beer can, and then later trademarking that phrase, "I bleed for the city," is crazy work. But again, I think this, again, underscores an important part of IP law. Before you start to disclose this stuff, you have to talk to an attorney or just see whether or not you want to protect it. Love Hurts. I actually think it's a dope shirt. You see the shirt that he has on here in the left-hand corner. I think that phrase is a dope phrase, a dope hoodie, dope clothing. Love Hurts. And somebody saw it. Let's think about this. So every year, whoever wins a Super Bowl, they throw a Super Bowl parade for them in their hometown. So obviously Philadelphia, they won it this year, and they attend a Super Bowl in Philadelphia. Before the parade ended, somebody had filed a trademark application on the term "Love Hurts." Now, I'm not sure how long a parade parade lasts. I would imagine a couple hours. So you got to think somebody saw his shirt and they had to file for the trademark application right then. And again, it's not like you click 2 buttons and you're done on a trademark application. You got to input information. You got to do a number of things. So somebody saw the value that Jalen Hurts saw with that shirt. And I'm not sure. It seemed like Jalen Hurts did not file it for trademark protection, but this lady in the crowd filed for trademark protection before the actual parade ended. So again, before you guys start to kind of disclose stuff, and this is whether it's patents, whether it's trademarks, whatever IP you have, you need to kind of strongly consider, maybe reach out to your team, maybe reach out to your attorney to say, hey, this is what I'm thinking about doing. I'm wearing this Love Hurts shirt at the Super Bowl. Is this okay? Should I maybe kind of try to protect it? What do you think about it? And your counsel is going to give you hopefully some good advice on that. It seems like hopefully Jalen Hurts was not trying to kind of protect the logo, because if he was, then he kind of missed out on that. It seems like this lady in Philadelphia, they saw an opportunity and they filed for trademark protection. So again, this stuff is valuable. She didn't file for trademark protection before the Super Bowl parade ended because it was funny. No, she saw the value in it, and I would imagine that she's going to be coming out with t-shirts and hats and hoodies and whatever the case may be, using that "Love Hurts" saying, like "Love Hurts" phrase. So you guys have to make sure that you are protecting your IP. And then we're going to kind of move on here to the lawsuit of the week, Michael Kors. Now we are going to pull up this lawsuit, and I'm going to go through it so we can kind of see what it's all about. But just to kind of give you guys some background information, Michael Kors, the famous, I'm not even sure if Michael Kors, does Michael Kors sell clothing or is it just handbags? Clearly, I'm not buying Michael Kors stuff. So you guys have to let me know if they're selling clothing as well as handbags, or if like handbags and shoes is like their big thing. So Michael Kors here, you see the picture to the left, that MK is the famous logo of Michael Kors. And then I think they do have the pattern that's MK as well, which they have a trademark on. Seems like a company called Marco, hence the M, you see to the picture on the right-hand side of the of that photo, and this is an interesting case because Marco actually got trademark protection on the actual his M as well as the term Marco for handbags and stuff like that. He also seems like, I don't know. You guys have to let me know. Does this MK and M, are you going to be confused of it, or do you think it's not a likelihood of confusion, which again is a standard of trademark law? It seems like your boy Marco, like I said, he got a trademark. So the USPTO, or at least an examiner at the USPTO, did not think initially it was trademark infringement or it was a likelihood of confusion, and therefore they issued him an actual trademark on his M logo as well as the term Marco for handbags. It seems like Michael Kors later on filed a petition to actually cancel Marco's mark at the USPTO, and it seems like they later filed this lawsuit, which is the topic of discussion here. So let me kind of share my screen here. Let me share the lawsuit. Is this it right here? Yeah, this is it right here. Let me bring it up. You see here, this was in the Southern District of New York. Michael Kors LLC in MKP fashion. I'm not sure what the K and the P stands for, but the M stands for Marco. So let's read the cause of action. MK, a famous and world-renowned fashion brand, through this action seeks to, among other things, stop MKP from continuing to flagrantly trade off Michael Kors trademark rights and goodwill by selling product that shamelessly mimics MK trademarks, trade dress, and designs, confusingly unknown multitudes of consumers into buying MKP products who intend to buy MK famous handbag and other products. So what they're saying is, hey, people are looking to buy our Michael Kors bags and they're instead purchasing this Marco bag. According to MK, MK brings this action for trademark infringement, trade dress infringement, false suggestion, and a number of other things under the Lanham Act in New York State and common law resulting from defendants and Marco's importation, advertising, marketing, promotion, and pretty much is infringement. So this is the Michael Kors trademarks, the MK. Obviously, you have the pattern M, and then you have Marco's. So again, like I said, Marco got trademark protection on his mark originally. Now I want you guys to let me know in the comment section, do you think Marco's trademark, which is at the bottom here, the M that's in a circle, as well as his kind of pattern, you see the word Marco right here, do you think that's similar to the Michael Kors branding up top? I'll tell you what, man, as an IP attorney, I got to be able to argue both sides, but it definitely looks similar. I want to know from you guys in the chat, do you think that Marco trademark at the bottom there, which is the M in a circle as well as that M pattern, is it similar or is it confusingly similar as the Michael Kors logo up top? According to Michael Kors, they think it's similar. Let's find out what else they're saying. So the defendant is Marco has wrongfully and fraudulently filed trademark applications and has obtained registration in the infringing M circle logos with the USPTO. So again, Marco actually got trademark protection, which is, look at that's even more interesting because typically when people file for trademark, when they file a lawsuit for trademark infringement, typically the person who's allegedly committing the infringement doesn't have trademark protection on the actual logo, on the actual word. In this case, Marco or MKP Holdings actually has trademark protection on the M in a circle as well as that M pattern. So the USPTO granted them trademark protection on it. And I'll tell you, as an attorney, Michael Kors, they definitely dropped the ball. But let's kind of get through the article here. So defendants' unlawful infringing products are confusingly similar. Yep. As a direct and proximate result of defendants' unlawful conduct, Michael Kors has been irreparably harmed. Let's see. Do I want to read that? Let's try to get to the factual allegations. That's where normally you're gonna get all the juicy stuff. Launched over 40 years ago by Michael Kors, a world-renowned designer, plaintiff designs, manufactures, produces, promotes, and advertises, markets, offers for sale and sales collection of goods, including bags and a number of things. I'm not going to read off all those things. The MK circle logos and signature MK pattern are owned by Michael Kors, are valid, subsisting, and are in full force and effect. Michael Kors has been making use of the MK circle logos and signature MK pattern in commerce long prior to the acts of defendants. I didn't realize that Michael Kors is 40 years old. Clearly, it's a famous brand. Let's continue on here. Plaintiff owns exclusive rights. So Michael Kors owns exclusive rights for plaintiff goods in it to his famous Michael Kors circle logo and signature MK pattern, which are inherently distinctive and non-functional. Michael Kors goods are sold in brick and mortar stores across the U.S., including through Michael Kors' own branded brick and mortar retail stores, as well as leading third party. Okay. Michael Kors goods are also sold online across the United States via various retailers. I would agree with that. Michael Kors introduced the Michael Kors line in 2004, consisting of handbags, totes, small leather goods, apparel, footwear, lingerie, and ready-to-wear. Since the introduction of Michael Kors in 2004, the list line has expanded to include jewelry, eyewear, watches, and other accessories. So, man, they didn't create the whole thing off the Michael Kors brand, which is what you want. Plaintiff earns billions of dollars in sales in the U.S. annually, as his Michael Kors line quickly achieved iconic status through the U.S. Since at least 2007, Michael Kors has continuously used his famous Michael Kors circle logos and signature MK pattern. Man, they done made billions. And everybody should have a business. I'm telling you, everybody should have a business. That's what I think as a IP attorney. So attached here is a Exhibit A are images of Michael Kors goods bearing. So some goods that we're not going to pull up these exhibits here. Michael Kors has invested and continues to invest millions of dollars in the U.S. annually to promote his famous MK circle logo and signature pattern. So essentially they're saying, hey man, we have spent a lot of money on marketing and advertisement. Indeed, over the last 15 plus years, Michael Kors deliberately and intentionally created brand awareness and consumer loyalty around the iconic MK circle logo and signature MK pattern, which plaintiff has used. Okay. Michael Kors prominently and consistently features plaintiff goods that bear the MK circle. I'm trying to get off to what your boys did. But let's give some of this to get off into what the bad actor has done. They're talking about, actually, I do want to talk about this. So if you look at 32 here, Michael Kors circle logos and signature MK pattern has achieved famous status under the Lanham Act. And I'm going to bring it back on myself here really quickly. Once your mark achieves famous status, then it's an elevated level of protection. So what does this mean, Dave? So this means typically when you file for a trademark protection, you have to let the USPTO know what class you're going to be using your mark in. So for example, I need to get some type of sponsorship with Topo Chico, but Topo Chico, they sell beverages, or in this case, water. I think they sell like alcoholic beverages and maybe non-alcoholic beverages. But so when they're filing for trademark protection, you see the R in the circle here, it's probably too small. But when you file for trademark protection here in the U.S., you have to let the USPTO know what classes you're filing your trademark in. So in this case, the Topo Chico is going to be filed in the beverage category, beverage class. But then once your logo or your mark reaches famous status, now you can go after other people, even though it's not necessarily in your class. So say, for example, and this is really a rough example, say somebody try to come out with a Topo Chico like lip balm or Carmex. Topo Chico, to the extent that their mark has reached famous levels or famous status, it can actually go after that person, even though the good is not beverages, is lip balms or Carmex or whatever the case may be. So once your mark reaches famous status, then you can actually go after other people for using a confusingly similar mark in categories that is not necessarily dealing with what you're dealing with. So in this case, Michael Kors, obviously, like they said, they deal with eyewear, apparel, jewelry, things like sort of clothing. Look, if somebody is selling a Michael Kors, I don't know, blanket or something like that, or Michael Kors like Carmex or water bottle, they can actually go after that person because their mark has reached famous status. Hopefully you guys kind of understand that. That is, I think, an important part, for people to understand. Once your mark reaches famous level status, then you get a elevated or a heightened level of protection on your mark. And again, that's what it's really talking about in paragraph 32, paragraph 33. And that's talking about the same thing, man. Let's get off into what the defendants. Okay, here we go. Defendants infringing activities, USPTO applications and registration. Now we're getting off to the good stuff. So in October of 2017, Marco filed a use-based application, trademark application with the USPTO. So that's the application they filed to get essentially a logo with an M in a circle. And the logo was registered, according to paragraph 40, the logo was registered on December 18th of 2018. So what? Almost a year later. In connection with the following goods, which comprise some of the infringing products. So they, again, backpacks, briefcases, I'm not sure what a clutch is, evening bags, handbags for ladies, handbags for men, a number of different things. Seems like on January of 2018, they filed a use-based application, again, with the M in a circle, but this time they seem like they added color to it, which is gold in this case. That was registered the following year of December of 2018. And again, similar handbags, tote bags, clutch purses, evening bags. That was the classes that it was protected in. Seemed like they got fancy with another M in a circle. See, it seemed like this is a regular M. It seemed like this M is a little bit different. And again, they recently did this in 2022, and it was just registered last year. Defendant makes extensive use of a repeated M pattern that appears in various iterations, including as followed in connection with the infringing product. So again, this is their M pattern. You see the Marco there. It looks very similar to the MK in my opinion. Let me know if you guys disagree with me on that, but I think it looks very similar. Plaintiff's MK circle logos and signature MK pattern are distinctive and famous and were so prior to defendant's alleged first use. So essentially, Michael Kors is saying, hey, our stuff was famous and distinctive before Marco started to file for trademark applications. There again, this is the MK in a circle. This is Michael Kors' trademark, the MK in a circle. Upon information of belief, Marco has imported, advertised. So essentially, they kind of sold these goods in the U.S. In violation of our trademark. Plaintiff has, okay, so it seemed like it was some investigation, did some third-party investigations. So Michael Kors has confirmed by working through an investigator to order and have shipped certain of Marco's products into the district that defendant has imported, advertised, marketed, promoted, distributed, offered for sale. So it seems like it's saying, hey, we had our investigator purchase some product from Marco. Look at man, they gonna throw up it upon information of belief, infringing products of Marco's are inferior of quality of goods. So they're saying, hey, Michael Kors is saying, hey, we have some quality goods. Marco's goods are inferior quality to ours. That's almost like a shot. Maybe it's a true statement at the same time. Let's continue on here. And then this is the big thing. What do you guys think? You see the MK in a circle, then you see the Marco or the M in a circle. So to the left here, you have the famous Michael Kors logo. To the right here, you have the inferior Marco logo, at least according to Michael Kors. What do you guys think? Are these two things confusingly similar? They look pretty close to me. Again, this is the same thing with the pattern. You see the MK pattern, then you see the Marco pattern below it. So let's move on here. Defendants infringing Marco's infringing M circle logo and infringing M pattern are intended to be confusingly similar to plaintiff's famous MK circle logos and signature MK pattern, as Marco has slavishly copied Michael Kors circle logos and signature MK pattern, is using a copycat infringing MK circle or M circle logos and infringing M pattern on the same goods. You see the handbags. Like I said, man, it looks similar to me. Confusingly similar. I think they got an argument. You see the MK logo on a handbag. You see the M logo on a Marco's bag. You see the MK on a purse. You see the M on a purse. Man, it seems like they got something to me. Okay, we got something else. You see the M pattern on this bag or this tote bag. I'm not sure what you call this thing. You see the MK pattern on this. So it seems like, hey, look, if I had to guess, Michael Kors, at least they're not far-fetched. I know sometimes you read these articles and you're like, man, this is far-fetched. Seems like in this case, they may have something. They even got the slip-on shoes. You see the MK, then you see the Marco. By no coincidence, Marco's infringing M circle logos and infringing M pattern mimic Michael Kors' famous MK circle logo and signature MK pattern. For example, The bold font Michael Kors uses for the letters MK at the center of his famous MK circle logos is nearly the same defendant selected for the letter M at the center of his infringing M circle logos, as is the width of the letters in a circle. As another example, similar to Michael Kors' placement of the Michael Kors and Michael Kors within his MK circle logos, Marco uses the name at the top and bottom of his infringing M circle logos. So it seems like there's a lot of similarities that we're seeing here. Let's go to item 60 here. Marco's infringing products employ its infringing MK circle logos, infringing M pattern, and or other design elements in a manner that it purposefully copy Michael Kors' famous MK circle logos and patterns. Okay, yeah, we get that. Let's see what they're saying here, man. There was some juicy stuff in here. Are approved, endorsed. Okay, so they're saying a similar thing. Check me out. Consumers who associate the inferior infringing products with plaintiff goods believe that Michael Kors goods are of inferior quality, tarnishing and injuring Michael Kors' business reputation. So it seems like, okay, here we go. Multiple consumers have posted comments online stating they mistakenly purchased the defendant's infringing product because they believe they were purchasing plaintiff goods. Such online comments also show dilution and the likelihood of association of Marco's infringing M circle logos, infringing M pattern and designs of infringing products with the Michael Kors. This is what you don't want. If people are saying, hey, we purchased this product because we thought it was yours, that's not a good sign, because that's like kind of really the hallmark or kind of what the likelihood of confusion or trademark infringement is all about. Is your brand, is your logo, is your word mark, is it likely to cause confusion among consumers? And to the extent that it is, it's probably going to be trademark infringement. And what they're saying in this case, Michael Kors is saying, we have already had customers that have said that they purchased this Marco bag or this Marco purse or this Marco jewelry or Marco apparel thinking that it was Michael Kors. That's not what you want. That's not going to help Marco out. And I would imagine that's going to settle anyway, but that's definitely not going to help Marco out if this one goes all the way and goes to trial. Marco has not now and never have been authorized. Okay, so you obviously didn't give him authorization, filing information for relief. Marco foregoing acts have been willful. So this is an interesting thing. I want to get to this one because I think this is interesting. Trademark trial and appeal board proceedings and fraudulent filings by the defendant at the USPTO. Let's see what they're talking about here. So on June 5th, 2024, Michael Kors filed cancellation proceedings at the trademark trial and appeal board, the TTAB, I'm going to call it, against the infringing M Circle logo registrations. On July 16th, so the next month, Marco hearing filed an answer in each of the TTAB cancellations against each of the essentially the registrations. The TTAB cancellations against each of the registrations were pending as of August of 2024. A declaration of incontestability of a mark under Section 15 must be filed as a prerequisite for trademark registration to become incontestable. Okay, whatever. Defendant submitted on August of 2024. Marco submitted to the USPTO a declaration of incontestability of a mark under Section 15 in relation to. So I see what they're saying. But it was 5 years. So pretty much, for a mark to become incontestable, once you file for a trademark protection, you get your mark registered. After you use your mark consistently for 5 years, you can file essentially something that's called, hey, my mark is incontestable. And essentially what that means is nobody can come later on and say, hey, this company doesn't have a valid trademark. This trademark is invalid. They can't contest the trademark. So once your trademark has been registered and you file for and you've been using that trademark for 5 years in commerce, you can file with the USPTO this document saying, hey, I have an incontestable mark, and no, to the extent that you've been using it for 5 years and everything is good, then the USPTO is going to recognize that, so nobody can come contest your mark at a later point. So that's essentially what incontestability is. let me kind of get back off to the what's the name here. In each such section, Marco stated the signatory being warned that willful false statements. So it seems like what Michael Kors is saying is that Marco actually filed for incontestability, and it was they didn't satisfy all the requirements that you needed to prove incontestability and such, and therefore the declarations that was made were false. That's essentially what Michael Kors is saying. Defendant knew that the statements of his Section 15 declaration under 1001 were false. Marco had recently filed an answer in the ongoing cancellation proceedings against each of the registrations. So essentially, Michael Kors is saying, hey, it was false. They filed for incontestability. Marco filed for incontestability of his mark, and that was false. So if the owner of a registered mark cannot truthfully sign the Section 15 declaration statement, pending not fully disposed of either in the USPTO or in the court, then such owner cannot legitimately obtain incontestability. Okay, that makes sense. You have to submit this declaration and kind of be able to attest to all these different things. And to the extent that one of these things is false, you don't have incontestability of the mark. But that has nothing to do with whether or not the mark has been registered. So it seems like in this case, at least from what I'm seeing so far in this lawsuit, that back and forth between the Marco and Michael Kors at the T-tab, which is a part of the United States Patent and Trademark Office, seems to be continues to be ongoing. So in other words, Marco got trademark protection on its eminent circle as well. It's kind of named Marco, and it seems like Michael Kors, when they found out about it, they filed a petition with the USPTO to actually cancel the mark. It seems like those proceedings are still ongoing. So I'm not sure why they brought up this whole incontestability. Yeah, I guess if Marco lied on this Section 15 declaration saying that we have an incontestable mark, okay, maybe you can't kind of check the box that your mark is incontestable, but that has nothing to do with that. Okay, you still have a registered and an active trademark that's in good standing. So again, I'm not sure what's going on with that, but let's kind of finish up this lawsuit here. So these are essentially the counts here. Our defendant has wrongfully asserted that its registrations are incontestable and has therefore claimed that such registration cannot be canceled by the plaintiff. Oh, that's why they did that. Because when Michael Kors tried to cancel the marks, like I said before, part of your marks being reaching that incontestability is they can't be canceled by somebody who's doing it later on. Now, obviously, it seems like Michael Kors is trying to cancel the mark, and that's what's going on. So Marco pretty much saying, hey, they can't cancel our mark because we've reached incontestability status so that they can't file a petition to cancel the mark. And Michael Kors is saying, hey, they did submit this Section 15 declaration showing that their mark was incontestable, but they did that that declaration that they submitted was false, and therefore their mark can be canceled. Essentially, that's the argument that Michael Kors is making. I get what they're saying now. Yeah, this one is getting juicy. So these are the different counts: trademark and trademark dress infringement. So the actual pattern is considered trade dress. So they're saying it's trade dress infringement against the Michael Kors pattern. Then you have some other stuff: unfair competition, false designation, and so forth and so on. Maybe some state law claims in here. And that's the prayer for relief. So again, you guys have to let me know what you think about that, man. That's an interesting one. It seems like we got some new stuff in terms of incontestability. Seems like Michael Kors, we all know the famous Michael Kors mark. And hey, I still have to be able to argue for Marco, but it seems like Michael Kors has a good case on their hand about trademark infringement, about trade dress infringement. So I would love to hear from your guys' thoughts in the comment section. Do you agree with me? Do you agree with Michael Kors? Do you think that this Marco trademark is like is confusingly similar to the actual Michael Kors mark? It seems like Michael Kors has actual they already have people saying that, hey, we purchased this Marco bag or this Marco apparel thinking that was Michael Kors. And I can tell you as an IP attorney, that's not a good sign for Marco. So we'll see what happens. We'll see if Michael Kors continue to or Marco continue to use a mark, or if it gets canceled at the T-tab, which is part of the United States Patent and Trademark Office. We'll see if they actually settle this lawsuit. Again, there's a lot of stuff that's up in the air. I thought this was a pretty juicy one. Hopefully you guys got something out of this. As we wrap up here, please hit the like button if you enjoyed this, as well as hit the subscribe button to be a part of the IP community where we talk about a lot of different things as we kind of have went through here with today's show. And hey, I'm excited to come back to you guys next Sunday with another fabulous show. So again, hopefully you guys got something out of this. Please let me know your thoughts in the comment section. Hit that like button, hit that subscribe button, and I'll catch you guys next week. Peace.